Hi, good morning, everyone. It is 25th of January, and I, on behalf of Bar Council of Punjab and Haryana, welcome all you to this webinar. This webinar basically is an academic initiative by Bar Council of Punjab and Haryana to ensure that legal fraternity has good, relevant speakers, listeners, and learners on the subjects that are of importance to all of us as lawyers and as citizens. Um, as humans because something sometimes are associated with human rights. So right now I sit with me with a wonderful panel of ladies who come from diverse background of litigation, of a mix of corporate and NGO, academia, and mix of litigation to discuss on a very sensitive topic with respect to protection of children data. When we talk about protection of personal data. All of us have been reading a lot about it in recent days because of passing of the digital personal data protection rules in India. But when we talk about children data, we talk about a certain category of vulnerable group which needs to be protected specifically because of the type of usage that might come out of their information. So I'll quickly introduce the wonderful panelists I have. So first one is Advocate Shalini Fernando. She is dual qualified lawyer, Supreme Court of Victoria and Supreme Court of Sri Lanka. She comes with a very diverse experience as she is working on child rights in Sri Lanka and has done a lot of pro bono activities with respect to LGBTQ, women rights and children rights. She is also board advisor for Emerge Lanka, director at SPD Marbles and Granite Private Limited in Colombo, Sri Lanka. She is also company secretary at Registrar of Companies of Sri Lanka. Welcome, Shalini. We're glad to have you here. The next speaker we have is Advocate Arundhati Kulshresht. She is Assistant Advocate General and has 10 years of total experience. She has educational background from Symbiosis Law School and Jindal Global Law School. She also worked as judicial clerk in the Honorable Supreme Court under Honorable Justice R.V. Ravindran. She has also been a research associate with different NGOs and worked on gender issues, international trade issues. Hi, Arundhati. I welcome you here.
Thank you so much.
Next is my ex-professor. So I have the privilege of being taught by her. So I welcome Advocate Nandita Batra. After her stint in academia, she has now moved to litigation. She's a practicing advocate at Supreme Court of India and consultant and visiting faculty in Center for Health and Law Policy and Ethics, National Law School, Bangalore. She has worked on public health law, feminist jurisprudence, gender studies, criminal law, and intellectual property rights. She has a bachelor's in law from Punjab University and master's in law from National Law School, Bangalore. And welcome, ma'am. It's glad to be
Thank you,
a
ma'am, for this invitation.
moderator where you are panelist.
Thank you so
So,
much.
um, before we begin, before I give this stage to my panelist, I would like to discuss on a few things that I believe as the moderator, which are essential. One thing is that when we say there's a digital life, there is a general life that we live, then there is a parallel digital life. How does that digital life impact children? Because we, in our daily lives right now, also are in a virtual world discussing something which is very um, core to the human values. Now, when we talk about privacy, in India, the question of privacy was first discussed in K.S. Puttaswamy versus Union of India. So, my Indian lawyers would, co-panelists would resonate that for the very first time under this judgment, Supreme Court said that the right to privacy is a fundamental right of an individual and needs to be protected like any other right, equivalent to right to life. So when we discuss this, we have a lot of questions around how children data is being utilized by different entities which are commercial in nature, beginning from edtech to social medias to e-commerce website who are targeting certain set of people in order to gain their marketing benefit, or even utilizing the data in a way that directly might not impact the child but might have a very long consequences throughout their lives. With this, I now would request Shalini to come in and explain us what are the global perspectives about child data. What is actually the child data and how do we define it globally?
Thank you, Hema, for that very kind introduction. I didn't know it sounded so good when you said it out loud, but just to clarify a few things, I'll do so through the slides as well. So I agree with the topic, with the direction it's going, and I'm very thankful to the Indian Bar Council of Punjab and Haryana for organizing this. It's a very relevant, a very required, and a very futuristic topic. And a special thanks to Savir for actually recommending me. Thank you. The only gent who was involved in this. It's all ladies after this. So I've got some slides. I'll take you through them by sharing my screen. Just for the viewers, it's going to start with the global standard, then move into the Sri Lankan standard, and I'll be finishing with tech, something that I've been trying my best to learn these last years because it's extremely relevant to us now. So I will get my slides up. Please bear with me. Here we go. Share the screen. Here comes the tech issues already. I did see a share the screen button. Sorry, I'm only familiar with Teams.
So if you could find it, it would be below in the toolbar and marked in green.
Thank you. Thank you, Hema. Please let me know when you can see my slides. Is it visible, the screen?
Not yet, Shalini.
Okay. Just give it a minute, but I'll start talking until then. So just a disclaimer, all images used in these slides are actually AI generated. So no children's actual data has been used. AI images generated and also some extracts from legislation. So I think I might just proceed. I hope you can see my slides. If not, I'll just share it after the lecture. Is it visible yet?
No, Shalini.
No.
So if you want, I
Okay.
can project, but I have the older one.
Actually, please do project. I'll
Okay.
just talk of the older ones. That's fine. Sorry about this.
No problem.
Still nothing. That's fine. You can go ahead, Hema, please.
Let me know if it is visible.
Yes, that's working. Thank you. So this is presented specifically for this topic. It is not anything beyond it. So thank you, Hema. So the global standard, you can obtain the full text from the link on the screen. But these are based on the United Nations Convention on the Rights of the Child. I'm sure everyone is familiar with this, but for the non-lawyers, This is what it is on the screen. So there are a few key ones that are relevant to us for today's discussion, data protection on children. So we can move to the next slide. Here comes the definition under Article 1, what is a child? So it's always good to start with the basics, basically anyone under 18. It's the same in Sri Lankan law and in the jurisdictions that I've practiced. So I think everyone is clear on that. Thereafter, we can move to the next article, number 12, respect for children's views. So with this article, it's a general one. I won't read it, but it's just a general thing that we should consider as lawyers and legal professionals, and hopefully one day judges with the litigators in the room. And then the next article is regarding 16 and 17. And 16 I have bolded and I have written it out, and I will read it out. Number 16 says, every child has the right to privacy. The law must protect children's privacy, family, home, communications, and reputation, or good name from any attack. Now that is the general one on the top left of the screen. The entire article is written at the bottom, and I'll let you take a moment to appreciate it, because it was drafted in a very broad sense that'll help practitioners who are faced with data breaches for children to incorporate it into their arguments and their submissions to court. It's very useful for this topic because right now data is being mined a lot. We don't even have control over it, right? So even when we take a photo, if you use Google Photos, Google owns it. So maybe it's not open to the world, but it's certainly open to an organization. And that is an organization beyond your government, beyond my government, and actually beyond all the governments of the world, which we'll come to later. That's the tech part of it. 17, access to information, is kind of the flip side of it, where what will you allow your children in your care or your schools, your orphanages, to access? Is it going to be only educational? Do they watch cartoons? Are there recording devices on the electronics that will hear and see your child? Because during COVID-19, we had a huge rise in that. Everything went digital, including in Sri Lanka. Even the poorest schools on the island got donations of laptops and computers, and everyone was online. And it was a two-way, just like this call. So that's another consideration for statutory drafters to consider. We can move to the next slide and the next article. This is my favorite article. This is the best. This is the overarching. You can use this as your Hail Mary for anything. Best interests of the child. You can always argue. You can always say, no, this is actually in the child's best interests for X and Y reasons. This is also something that I noticed a lot in Australia when I practiced. It's incorporated into their legislation very nicely. The Federal Circuit Court and Family Court of Australia uses this best interest of the child principle in a lot of case law, and it is a very good guiding light, I would say, as to what is the reasonable standard when we do our reasonable test. So this is actually the global standard. Whether it is incorporated into your law and ratified is another matter, but this is the standard globally that we hope for. Now, GDPR is different. This is a UN-based one. GDPR is completely different, but if these standards are incorporated into legislation, it would be a nice start to a big problem. So this brings me to the end of the global standard. I'm keeping it very short, but if you would like, I can elaborate later. We'll move to the next part, which is something I call a human standard, right? So something in between. And the image is something I experienced in the last 2 years of my life after having a son. Uh, that reminded me of me when I had to report to work. Not that I did it in this manner, but I've seen a lot of mothers trying to juggle work, family, home, parents, it's so much. And this, like, the reason I put this image is if her laptop is on and she has a video, and if it's active and she is unaware, maybe she forgot, that means the child is already exposed, right? It happens sometimes. It's a human error. That's why it's the human standard. So you have to protect against a lot of things, not just the intentional, but also the unintentional, at least for the child. Now, that is the point I want to drive in. You have these beautiful standards globally. You have a human touch. So with that, can you protect your child? So the responsibility of a parent is there, but also as a society, because when I look at the orphanages in Sri Lanka, I see those as my children too. And I have a duty to them, even if it's to just talk about it for now, because their rights need to be protected too. So that's just, nothing to do with law, just being a woman and a mother. We'll move to the next slide about the Sri Lankan standard. So we are your island neighbor, and this is our Online Safety Act, which is actually quite good. It is in effect, we use it, and basically there are provisions in it that will help practicing lawyers who are faced with online safety issues for children, whether it's a data breach, whether it's revenge porn, even for children it has happened. So this act will assist with that. On the next slide, you will see the specific provision, number 21, which deals with child abuse. And on the screen, you will notice sections of the Penal Code. So the Penal Code of Sri Lanka has this list of offences, and the Online Safety Act quotes them, so they're interrelating the two acts. So you rely on section 21, you check whether you have any of these provisions that you require. And on the second paragraph, they say, because the Penal Code refers to women, this replaces children with women, so it's interchangeable. There are petitions as well to just put the man in as well, because everyone can be subjected to these offences. And there have been certain amendments made to make it more gender neutral. So we do take care of all genders, or hope to. On the next slide, you will see a small extract. This extract is the schedule to the act, and it just gives, just for the viewers to see what it looks like in Sri Lanka, what the Penal Code states is the offence and what is the punishment. So this would be relevant to everybody under the age of 18, which is wonderful. Thank you. And next slide, please. The Personal Data Protection Act of 2022. It came out 2 years ago, but only certain provisions of the act were in effect. So the ones that are coming out this year in March 2025 make the entire act effective. So everyone at the moment in Colombo is reading everything in this and trying to figure out, are we compliant? And I had the privilege of speaking to somebody who drafted this or helped draft it, and I will share his input on that next slide as well. So this particular slide is regarding a hashtag campaign called Protect the Child. It was done by Imaj Lanka. I used to be an advisory board member, but it was mostly pro bono now. And now I just help them with awareness. And whenever they have a litigation issue, I actually channel it to my husband, who's the litigator in the family. So Protect the Child campaign was done in Sri Lanka. It was very successful in the sense of what they did was they created a trilingual, so all three local languages, Sinhalese, Tamil, and English. They drafted, and this is why I had to add it in, but I'll share it after this. They drafted help guidelines. So if you are in a situation where your child is in need, or if you see it happening, this is what to do. And they also help further by saying this is how you spot it. If you don't even know it's happening, this is how you spot it. So they did a very good job with this campaign. This hashtag actually went quite viral, and the founder is from the United States. So she has a very big reach, and just to tell you the long and short of it, Emerge Global and Emerge Lanka, they run programs to rehabilitate and reintegrate rape victims, so children who have been raped. If they get a spot at Emerge, and they take about 12 a year, they will house them, they will educate them, they will heal them, and they will give them the best available resources that we have to get them back up. And we are very proud of them as a nation because it's a very expensive exercise. It costs millions to do this. And they're on their 12th batch, I believe, at the moment. And this concept of rehabilitation and reintegration of these victims is how they came up with this hashtag and why they launched it. So at the moment, it's for girls. So we need one for boys if we get funding one day. And the next slide is also regarding the Protect the Child campaign because it was for girls. That Emerge is rehabilitating the girls at the moment. So that's the nutshell. I would just like to share one thing if I have time. Hema, please let me know if you need me to stop. I'm just going to share with you this article. So I did a fact check of myself with the legal points, and I checked with the State Council, someone very similar to Arundhati actually in Sri Lanka, and he said, yes, the law is fine. Then I asked somebody who is very good with tech, and his name is Yudanjan Vijayvalaka, and he advised me from a tech perspective. And what I want to share with you is an article he shared with me and the viewers, because if we can get the lawyers talking about this, how is tech and law merging? Now it's already in one big heap. How do you untangle the children out of that? How do you legislate for that? Lawyers aren't able to legislate for this because we are not tech savvy enough. So if you get the tech savvy lawyers, if you start communicating with them, if you start getting their input as to what is needed, what is possible, because we're on a light web. There's the dark web. There are 9 layers of it. So I've been to the first layer and I didn't know what it was, and I just came back because it was something that I had never seen before. But I was shown it to understand what is the internet. How vast is it, and how unregulated is that? So when it comes to data protection of children, my personal opinion is that the digital footprint is nearly impossible to erase for children. It's automatic now. Even if you try your best as a parent, it's limited. At least an organization will own it. In terms of protection overall, legislation is good. We have provisions, we can argue. We have a convention globally, we can all argue, but in practice, does it happen? I would say no. So that is my opinion. I think there are big holes in the system. Not for a lack of trying, but just because the tech is going so fast, we can't quite keep up with it. So it's just a human error. So you got to kind of apply that human standard and figure out what to do in your jurisdiction. Sri Lanka is quite good in the sense of we have a cybersecurity unit. We have places you can go to and they take action fast. So it's not all bad. But I think I've taken more time than what was allocated to me. So thank you very much for your patience, Hema, and the panelists. I will hand over.
Thank you so much, Shalini. And we really appreciate, I think my co-panelists would appreciate the initiatives that Sri Lankan government is taking with respect to Protect the Child campaign and how proactive they have been with respect to certain causes. And as you rightly said, COVID-19 has brought in digital to our daily lives, and we are now more uh, working more closely and working throughout using digital platforms, which is true for our children also. The question of reasonable standard was brought in by Shalini. Arundhati, I would like to bring you in during this discussion right now because you have been protecting the state in certain matters because of your job. So I would want to understand from you what is the role of the courts in interpreting the and enforcement of privacy rights of children? Because when we say a child is somebody who's below 18 years of age, but recently we have seen there have been a lot of discussion around whether the age bracket is okay considering the digital developments that have been happening and how children are being exposed to what they were not usually during the age of 18 or before the age of reaching 18. So I would like to understand from you how well equipped our current societal as well as legal norms are to ensure that in this digital age we are protecting the right person in a right way.
Right. So, first, thank you so much for this opportunity and for such a glowing introduction. I'm overjoyed to be a part of this panel with such, accomplished women. It really makes my heart sing that we're talking about something like this, which is such an important topic. Also, a quick disclaimer: everything that I say is my personal view and does not relate to my office or my job at all. Before I start, I want to share this image with you all. And it is, again, the copyright is not mine. I have only downloaded these pictures from Google, and it is only for illustrative and educational purposes, and there's no commercial angle involved. And I'm sure that at least, maybe not Shalini, but at least all of our Indian counterparts here will be able to identify at least one of these pictures. And I'm fairly confident when I say that it is not because they were actually looking for these pictures, trolling the internet, but only because they are members of the society that use the internet. Now, these are three different people of different age groups, and the only common thread that runs through them is A, they are all minors, that is, they are below the age of 18 years, and B, at some point in time, they were harassed by, let's say, the paparazzi or people who had access to the internet. And just by innocently putting up their pictures, their right to privacy, in my opinion, was compromised. Um, so if everyone has had a view of the pictures, I think it sets the scene to what I'm going to say next. So, Hima, if I may request you to please take the pictures down. So the context is extremely important because the courts are a mirror of our society. And as Shalini rightly said, technology grows by leaps and bounds. And it is virtually impossible for the legislation to be able to keep up, both in terms of the laws as well as the contours that the laws have to take, because they cannot be very strictly worded, they cannot be very loosely worded. So the role of the courts in that sense becomes very important in terms of the interpretation of those laws so that they remain progressive enough that they can shield the most vulnerable in society, in this case, the children and their right to digital privacy. In India, the role of the courts comes in two ways. One is in terms of enforcing Article 21, which is the right to life, which encompasses the right to privacy. And the other is in terms of enforcing a new act that has come onto the scene, which is the Digital Personal Data Protection Act of 2023, which is in a way a watershed moment in terms of Indian laws, which protects the digital privacy of individuals, including children. There's a special section on children in there. Now, there is no other generation other than the one which probably came a decade ago and continues to come in the future, the beta generation, as we know them, 2025 onwards, that will fully experience the reach, the impact, the permanence, and the pervasiveness of the internet, because these are the only people who have had a digital footprint literally since the time that they've been born. The contours, the impact, and the way that this is going to evolve is outside of our imagination at the moment. We cannot even at the moment discuss what will be the positive and negative impact of this development in our lives. That we have moved now to a place where not only is the protection of physical rights very much something that is on the onus of both the legislation in the courts, but also the intellectual rights, the mental rights. So you're not only protecting the physical health of children, you're also now, you need to protect the mental health of children. So in that context, the constitution and the role of courts comes in, because there is an interplay between Article 21, which is to protect the privacy of children, as well as Article 19, which speaks of the right to freedom of expression of individuals. So the intersection of the two, where information pertaining to children is then disseminated forward, which in a way I have done too by sharing that picture with you. Where do we draw the line? It is very hard to say that by using that picture, I am, as of date, not infringing that child's future right to privacy when that child becomes an adult. And in this context, under the DPDP Act of 2023, it is the parents who have been made the custodians of giving the consent. So DPDP Act, the underlying foundation of that is consent. It speaks of scenarios where consent is given and consent is withdrawn. And the safeguard here is that that consent has to be verifiable parental consent. Now, how that is going to come into play remains to be seen in terms of how what is termed in the Act as a data fiduciary, which is the entity that will be storing all of this data on behalf of the individuals. How they're going to do that? There will very well be issues in terms of getting that verification. Also, there is no nuance there. So there is this broad category of children. And as Hema was mentioning something about age of a child. Now, a child from 0 to 18, their requirements of privacy and their protection of their digital footprint is different. Some countries have made that distinction in terms of placing children below 12 in a different category and placing children above 12 up to 18 in a different category. And I think that is something that eventually we will also have to deal with. We are at a very nascent stage. It is a laudable step that we are at a place where we are protecting, we're talking of e-protection of rights, so to speak, of individuals. But having said that, that nuance has to come into play sooner or later, because this is a very, very broad category that has been put together and will need to be segregated, because a digital footprint is a necessary evil in our times. And even the right to education which children have gets impacted if parents go too far in terms of protecting their children and not exposing them to the internet, so to speak. So all of these questions will need to be answered by courts in some shape or form in the future. Also, there's a very interesting fact here that at least in India, the watershed moment for privacy, as Hema has pointed out, was because of the Puttaswamy judgments that came. And when that judgment came, and up to 2023 was the Goldilocks period, so to speak, for courts, because everything was under their jurisdiction in terms of what they could interpret and protect children. But with the advent of the Act, and the Act actually envisages the creation of a board, which is known as the Data Protection Board of India. And all complaints that now that pertain to the all the areas that are covered under the Act lie before the Data Protection Board of India. And although under Article 226, the court's jurisdiction is not ousted, but practically speaking, if there is an alternate remedy that is available to a petitioner, the line of thought is that they should first go and exhaust that and only then come to courts. There's also the provision of an appellate tribunal. So, at least in terms of the areas that are covered by the Act, which is where consent is the basis of any information being provided digitally, that has been taken away from, in a way, from the court's jurisdiction and put into a board. Now, tribunalization of justice, there are both pros and cons to that. And that is a conversation that we have to have another time altogether. But having said that, we have taken a step in the right direction. But I still think that there is a lot that needs to be seen in terms of how it evolves. And I'm very glad that we are having these conversations, because I think all of us have a role to play, both as members of society and relatives of kids in different capacities, to protect them, to safeguard them from threats that we don't even know what shape and form they will take in the future. Not just the kind where they're in the negative sense, but also in the positive sense, because very innocuous information that pertains to kids can also then be processed in a way that eventually their information, their right to privacy, is in some way infringed. So, with that, I think I've covered most of what I wanted to say, and I've taken one more minute than I should have. If you have any questions, I'm here. I would love a discussion on this.
Sure, Arundhati. Thank you for bringing in the point of generation beta, because I would be a parent of generation beta in some time. So it is for personally for me also very important to understand uh, how the landscape of that growth of that child would be, because it would be very different from how I was grown up and I faced the education, or I went to school, because lot of things are run now over platforms, edtech, wherein the question of whether my child is getting recorded and whether the performances that my child is doing academically, or even in the personal front, how a child might react to a certain situations, would be open in public without any recourse of removing those digital footprints, with available with me or with the child when the child want to exercise that right. So these are important questions that we need to think about as society at large. Now, I would like to move to a ethical perspective of it, because the questions that Arundhati has brought in are very uh, critical. These are very essential for us to understand how, um, when we discuss or when we say that we have a legislation in place which says that you need a consent from the parent and the consent should be verifiable consent, it imposes XYZ restrictions. But how important it is ethically understanding the dilemma of sharing information, sharing children's information, making available children's information over the platforms, and how to ensure that there is privacy there, how effectively the entities are required to ensure the fiduciaries, as Arundhati was saying, the or we would say controller under the definition of GDPR, who are running artificial intelligence platform, IoT devices, how important it is for them to be sensitive of the user base that they are catering to, and how as parent, how as society, we need to be ethically concerned about what kind of data flows to the data banks and how the data mining could actually happen. um, I'll request Nandita to come in here.
Uh, Thanks, Hema, for this background. And thanks, my co panelists, for bringing in the global as well as the perspectives that Indian courts have taken when it comes to privacy generally and with respect to children's privacy. So, before I begin, one of the issues that Hema posed to me on ethical concern is on monitoring a child's activity by his or her parents. How ethical it is because we understand that we need to protect the child. There is a legitimate concern. The child is a vulnerable person, that there is no doubt about it. But to what extent can one, the parents, go? To what extent can the state go? These are some of the questions that have been posed. Before I begin ethically discussing or legally discussing, let me share something that happened a month ago. If I'm not wrong, around Christmas this year, last year, there was a news item that outraged at least the Indian social media, which was that there was a girl of 16 years. She was preparing for competitive exams. If I'm not wrong, she was preparing for IIT JEE, and her parents had installed a CCTV camera in her room. And the question was, is it fine? And she complained about that. And the question is it fine? Is it ethically sound? Is it legally sound? To what extent can parents intrude upon the privacy of the child? So, the debate that whether children have privacy rights or not is no longer res integra. You've been quoting the case of Puttaswamy. We have seen the Convention on Rights of Child, which India has ratified, which Shalini spoke about. So we do have legal basis to say that a child has a right of privacy. But to what extent and how do we balance that is one of the questions. So while this did not lead to the courts, this debate or the example that I'm citing, it did not. I'm not sure if now it has found its way to the courts, but in other context, for instance, in the cases of DNA tests, where one of the parent often asks for the DNA test of the child, the question of a child's privacy versus the right of a parent as having control over the child's body have come before the courts. And the courts have said that, parents, while Indian law by default puts parents in a higher position that they can take or affect the decisions of the life of the child, it is not an absolute right to say so. So while we do recognize parental control over child, it is not absolute. And one of the cases that I would like to cite here, which is not in the context of monitoring devices, but it's in the context of modern scientific technologies, DNA technology, is the case of Aparna Jankia versus Ajankya Arun Firodia, where Justice Nagaratna, in her opinion, has cited the Convention on the Rights of Child and used the principle of best interest of the child to safeguard the child privacy and protect that from an unwarranted intrusion by a DNA test for a purpose which is not required for the health or the benefit of the child. So she noticed what is the contour of the best interest of the child. So, when you ask me a question whether parents have a right to monitor a child's activities, or whether they have this right, I would take a step back and say, while a child has a right of privacy, I'm really not sure whether a parent has a right of monitoring a child's data or activities. I understand that there are a lot of apps, any TV that you do has parental controls. Uh, Parental controls is fine. You give permission. So here also parental control works two ways. Parental control is different from parental monitoring. Parental control is you allow, you filter. It's like a pre-censorship that what my child can watch. But parental monitoring is I let my child do whatever he or she wants, but then I will monitor and maybe pass some remarks or maybe do parental uh, control after I monitor. So monitoring is more invasive, and I'm really not sure whether monitoring can happen. In fact, there are research studies by scholars across the globe which say that apps which allow for parental monitoring, they are rated 1 star or half a star by children, so they're not very popular. And they understand that. And legally also and ethically also, I do not feel that there is a justification for parental monitoring in the way that they can access everything that the child has. Not in India, but there have been cases in other countries, UK and Australia, if I'm not wrong, where these apps which allow for parental monitoring or surveillance or spy cameras, they have been held as violating the privacy of the child. though there have also been cases which arose in family disputes between the partners, between the parents. The courts have held against the use of these devices. So, answering the question that was posed, to what extent can the parents go? I definitely feel that there has to be a blurring line. But I'm also conscious of one thread that Hema, you've brought in, and which has been pointed by Arundhati, that there cannot be one size that fits all. Today, the definition of child is that anyone who is below the age of 18 years. I do understand that a child, an infant, and a teenager, who all fall within this broad definition, need to be distinguished. While I'm just drawing a corollary, and I think that might be a useful point for whatever laws we make in future. Indian Penal Code, if I take as one of the examples, or even BNS now, the Bharatiya Nyaya Sanhita, for the purpose of determining the criminal liability, they had incorporated this concept of doli capex and doli incapex, and it is not child up to 18 years. It is from 0 to 7, no criminal liability at all. 7 to 12, qualified immunity is given. 12 to 18, procedural uh, procedure differs. So from 12 to 16, the JJ Act will apply in certain cases. From 16 to 18, JJ Act will apply. But if it is a heinous offense, then you might be tried as an adult. So there is complete immunity, and there are procedural safeguards which have been enacted insofar as criminal liability is concerned. But we see that the modern legislations that have come in the recent times, including your Protection of Children from Sexual Offences Act, does not take into account this finer nuance approach. And we have a lot of cases where romantic relationship by children have been criminalized, especially teenagers. When parents don't approve of the relationships, they have gone to the courts. Even when the children are of an age, even their relationships are not approved, and habeas corpus petitions are filed. It's not so uncommon that a girl child, 20 years, 19 years, sees herself in the court at docks with her parents. The infamous Hadia case, where NIA investigation was launched by Kerala High Court, ultimately paused by the Supreme Court. Again, so parents have always tried to exert the authority, and I feel that there is a need to lay down in law what the parents can do, and to say that parents will never harm the children. This myth is broken. Incest, your Protection of Children from Sexual Offences Act, so many cases that I have encountered, it is either the parent or someone known to the parent, and they keep mum. So, we need to get out of this myth that, parents will always act in the interest of the child. We need to recognize that they can also bring harm, whether it is their overzealousness or whether it's their criminal activity. So we need to get away from this shard that, it's all good and rosy within the family. It's not. So there is need for control, and we need to identify that. Coming to the other issue. So, the first thing that I have tried to do is to explain that monitoring is very different from, anything relating to protection of data. Monitoring is the general reason which is given for monitoring is that we need child safety. There is cyberbullying. We don't know what kind of friends are there. We don't know what kind of transactions are there. So safety, welfare, protectionism. But as I'm saying, there needs to be a balance. The other aspect is you're not monitoring, but the data itself is commodity. That can give a lot of information about the child. It may not be harmful per se at that moment, but has other ramifications. So for that, I would just try to maybe reiterate what Arundhati had said, that now we have an act, the Digital Personal Data Protection Act, though it's not notified yet. The rules have come, the act is not notified. Section 9 is very clear when it comes to child, that there has to be a verifiable consent by the parent. Now, the purpose of this consent is very different from monitoring. It does not authorize in any way Section 9 or the Rule 10, which is now proposed, the draft Rule 10, which formalizes this, does not in any way give a mechanism for monitoring, does not pave the way. So processing of data and consent of data are two different things. And when it comes to the question of then, let's now move away from monitoring and discuss about why even this is provided in the law. Why is it that parents have some control, if not monitoring, some control over how the data of a child is going to be processed? Uh, the reason is, as I said, our law, including our Indian Contract Act, Section 11 of Section 11, who are people, I think 10, if I'm not wrong, who are people who are competent to contract. So a person who is not a major is not competent to contract, and child, by virtue of the Indian Majority Act, falls off that limit and is therefore not competent to contract. So whenever you are doing any kind of data processing, it is through a contract. It's not in the absence of a contract. So you fall foul of that basic limitation, and a contract with minor is no contract. But very interestingly, I feel that the Data Protection Act deviates and is in conflict with the contract law for two reasons. So if a contract is not done by a minor, the minor is not bound by it. And the Limitation Act, which we have, the child, after turning major within a certain stipulated period, can bring an action. However, under Data Protection Act, you are snatching away that and saying parents will give. So you're substituting the child for the parent. And the question which the Indian Contract Act raised was it a contract for necessaries, where it allowed someone else to, give consent for the child? That question of necessaries is not present in the DPDP Act. So I don't think the Digital Personal Data Protection Act has actually taken into account the entire conversation and the thinking that has happened in the Indian law on child. So I was particularly looking, as Hema said, that I particularly look at the public health aspect. And when I was looking at the health aspect, there is a schedule which provides for certain exemptions, and health institutions, clinical establishments, when it comes to child's data, have been exempted, which is okay, which is good enough for me, because these are cases where they require care. But what about other cases? So that concept of purpose limitation, that concept, and I do understand that what I said with respect to Indian Contract Act may not be enforceable, because today we cannot have that no digital devices for children. Like some countries have moved that way, that you don't have social media below a particular age. We are definitely not moving there. And I do understand that there are some voices which are not saying that no digital data, but which are actually talking about digital minimalism. Even that is not the standard that we have adopted, despite concerns that excess of um, excess of social media interaction has a adverse impact on the mental health of the child. So I think there is a lot more that needs to be discussed when you have to protect the child. Today, the Data Protection Act has been framed. I don't think so. All the stakeholders have been consulted. So it's not framed from a children's perspective, it's framed from an industry perspective. That's my understanding of the subject. And I do feel that, consultations should happen in a broader manner than they have already taken place. But whatever is there, the question is of verifiable consent, whatever we have, whether that is a sufficient safeguard or not. See, when you talk about whom are you talking to behind the screen, whose data are you processing, whether that person is a child or an adult, you have no means, because it's a blind screen, right? I don't know with whom I'm interacting. So there cannot be a mechanism only for the verification of the child. If it has to be a mechanism, it means you verify all the users. If it is voluntary, then you fall into the trap of everyone, saying that, yes, I'm not a child. That's what people have done, I remember this was a topic that I gave to some of my students for their project. I asked them to analyze some few years ago. I asked them to analyze the terms and conditions of Facebook, Twitter, other social media websites, WhatsApp, that what are the clauses and what happens if they say that I am below the age of 13 years, or it was 13 years, not 18 years as required under the Indian law. And nothing, you can simply say I am above 18. There is no verification. So what that is what, my children that I know have done.
Yes, age gating, you are rightly saying, Nandita, age gating would not just allowing the user to accept whether you are below 18 or you're above 18, whatever the question
There
could
is a
be,
lot of
might not be the right
false
criteria.
yeah, yeah.
Right.
So there is a lot of false inputs being given just because you want to access information, and it's not criminal by itself. So we do need a proper age verification, but I think even with age verification, we need to have a larger debate, because this is then uh, you know uh, breaking in the anonymity that the digital world brings with it. The digital personality that we have, it breaks into that anonymity trap. So how do you do that? The other question that you asked me was, okay, we need to have age verification, we need to think about monitoring data processing, but what about emerging technologies? This was the last question that you asked me. Coming to the last question, AI, IoT, biometrics, I certainly feel that we cannot stop our children and should not go for a standard that says, with respect to children, there will be no digital life. Like we say, with respect to children, there is no sexual life. It is only after 18 that you can legally have sexual intercourse. So we cannot have the same standard, say you can resume your digital life only once you turn 18. That is not the standard that I feel. But definitely, whatever has happened until they turned 18, they should have a right to erasure. Instead, so my proposal is, instead of giving parents the right to default consent for the child should also retain the autonomy. For a specified period after turning major, he can reverse the decisions if he does not agree with his parents. And I'm saying so not because it's some innovative idea, it's something that is there even in your Prohibition of Child Marriage Act, that after you turn 18, you can go to the court, get your marriage and declared null and void, but you have to go to do that if you were married as a child. Similarly here, if your data has been given consent to by your parents and you don't agree to, you should have a right to erasure from every space that it has moved into. So that's my submission. That is the way forward. I do not have any rule or regulation, because we don't have laws on AI or IoT as on date. But on biometrics, definitely Aadhaar Act talks about child and recognizes that they're vulnerable. So that's all about the questions that you posed to me. Thanks, Seema, for
Thank
this invitation.
Thank you, Nandita. That's a very different approach to how we deal with these questions when it comes to their interaction with child data. So I am completely resonating with you on your observation that we should have a right to erasure uh, when it comes to exercising autonomy of a child. Now, this brings me to a question that I would like to pose to the entire panel. That considering as per the mother document of privacy across the world is GDPR, General Data Protection Regulations of European Union, and they identify certain principles of processing. So these include data minimization, these include right to be forgotten. Do you think that considering children is a different group altogether, we need to have a different set of principles for children, and we should rather have a divide between an adult processing of an adult data and what principles apply to that, then processing of a child data and what principles should apply to that particular processing?
Hima, can I answer that quickly?
Yeah,
Because
sure.
one very pertinent example comes to my mind. There is this band called Nirvana, and they had an album called In Utero many, many years ago. And the artwork of the album featured a child, maybe a year and a half, 2 years old, underwater swimming, and one could see the child's private parts. Now, cut to today, and that child has now gone and asked for royalty and has not actually asked for that cover to be removed. But the fact remains that there has to have been consent at that stage by the parents who allowed for their child's picture to be used as artwork at that stage, right? And eventually, what has happened is that back in the day, if there were maybe two, three, four, five people who had the knowledge of who that child was, today it is public information, and everyone across the world knows who that child was as an adult today, what that child looked like, what that adult looked like, sorry, when that person was a year and a half. So the underpinning of this entire conversation revolves around consent. And the way that we look at it, the general idea is that children are incapable of giving consent. Now, I take it a step further. You know how Nandita talked about how parents can bring harm to children knowingly. What about the fact that the parents may not know any better? It is not just that they may willingly want to do something wrong, they may just not understand the consequences of what they are doing. That is one aspect of it. Whoever is in this fiduciary relationship with the child, parents as well as the data fiduciary, because the way that we stand right now, the only paradigm that is covered is where there is a relationship between the data principal and the data fiduciary, right? What about straightforward hacking, or a straightforward violation of someone's right to privacy? How are we going to tackle that? There is no question of consent there, right? This is just some third party that has decided to pick up data, crawl for it, and used it in whichever way, whether innocently or with, committing harm to the child. Regardless of that, it is still a breach of their privacy. And at the moment, I don't see any mechanism in place. And that is where I think courts come in terms of being able to somewhat define where this goes, because eventually we will have to have some sort of a balance in place where, like Nandita pointed out, the children are given the dignity that they deserve in this situation, in terms of being able to find out what is right to them vis-a-vis their naivety, in terms of being able to decide what is right for them. So these are very tricky questions, and we have to find the answers. But I think we are all, thinking about it in the right direction.
Sure, indeed. When we ask these questions, and I'm really very happy that the entire panel consisting of women are raising these questions. I don't know if the other side of the gender would be so sensitive about these topics and how these things impact a child and society at large. Um, Shalini, just wanted to understand from you, because Nandita also raised a point of how these companies are left unregulated from the while they are using IoT devices, providing those IoT devices, AI devices at our homes. We have Alexa, we have uh, our refrigerator, which we can operate through a Wi-Fi device. So, while there are lack of legislation, and while the courts are evolving the interpretation themselves, because recently I was reading in 2024, Microsoft has been held liable for violation of processing of child data without proper course of law, because they had a take it or leave it approach. So you either accept those terms or condition or don't use Microsoft Office, which was not an
Yes,
option,
yes,
which is right now not an option for many of us also. So you would be, once you have a new device at home, you won't be accepting terms and conditions because you want to operate that device. Otherwise, it will not provide all entire functions to you. How fair do you think this idea of take it or leave it is, and how it is disrupting the entire ecosystem of data management?
I think we should leave it, because if we do, then they'll change. So the only way to get the capitalists to stop and respect and provide dignity to its users that they are minting money off of is to leave it. I recommend everyone to just, we live in a beautiful part of the world, just enjoy nature for a change if you can. To answer your question and to add on to Arundhati and Nandita, very nicely presented, both ladies, with very good perspectives and considering legal points, case law. I have to say, when it comes to GDPR, I welcome the standard, of course. I'm happy that they drafted it. However, when it comes to children, it's non-negotiable. Uh, rights to erasure, the monitoring aspects, even from parents, and you're absolutely right. Most of our child molestation issues It's 90% incest in Sri Lanka. They're the biggest threat. The guardians of the children, the ones who live with them or the ones next door, they're the worst. So definitely legislate to first protect the child from the carer. And very rightly pointed out, maybe they don't know better. I mean, I only started reading about this 2 years ago because I wanted to know what happens if I put a story of my son. Does it, what's the effect? And then we started having debates about it because everyone's doing it. Doesn't seem like a big deal, but it is. And we're all kind of going with this flow. All the Alexas in everybody's house, we're talking to it, all of that. It's here. So I would say for adults, yes, it's your right as a human being to decide how much you want to use and expose yourself, but you don't have that right for a minor. It is not your right just because it's your child. They should reach age of majority, and then they can decide what they want to do. And certainly, right to erasure should be them. When it comes to monitoring, I'm horrified to hear these stories because I'm not following Indian news, to be honest, unless y'all are going to a different planet, and then we cheer from here as well because it's great for the subcontinent to have an achievement like that. But the girl who's studying for her exam to be monitored on CCTV, I mean, does she have to leave the room to, even change her clothes? Because parents are literally filming her. So, and then you add in the incest elements, then you add in the fact that that device that the parents are watching can be monitored by other people, and it's owned by another company. I mean, you're creating so many problems, and obviously they didn't intend to. They probably just want to see that she was studying and not gaming or something. But the law falls short. We need to reverse the narrative, especially in terms of the consumer. We don't have to blindly accept all of their terms. There are other providers. We can have our own software engineers grow them for us. And to be honest, for the last 1.5 years, I worked at Hitachi Sri Lanka, and all the software engineers, I learned so much because we did software licensing and service agreements. And you need to understand the tech first. And that is why I asked my friend who is very knowledgeable in it, because I know I have no idea in this topic. You got to talk to the tech experts. Like, ideally, legal panel, one software engineer, one data miner who knows what it is. People working at the data banks, what do they look for? Why did they take all of our information? Because they're trying to sell it. So how do you sell it and package us? I would love to know. And there's another thing we don't know. Our governments have a certain right. So I'll give you an example. When we had Aragalia a couple of years ago, and the Sri Lankan government literally toppled, social media went dark for a day, I think. I think it was a night or something. So the government switched it off because then we couldn't communicate with each other. Where's the next protest? La, la, la. So they have the power to do it. The government does. So does yours. Each country has that right against Google, against TikToks, against each provider. However, if they have the bargaining power to an extent, I'm not saying it's a great big power where nothing, I mean, Sri Lanka especially is a very tiny, tiny thing. Facebook probably doesn't even know where Sri Lanka is on the map because we're so small. But if you have bargaining power well, use it intelligently. Say we are leaving it. All of Sri Lanka will leave Microsoft Office. We'll make our own system. It's fine. Maybe it will be terrible, but it's okay. We don't want to give away the rights of our children. And on that note, I would like to say, and I know I'm taking too much time on this, but child pornography on the dark web is so vast. Why is nobody regulating this? Why is it unregulatable? Which is what the conversation I had with Dungeon, because he was like, it's not for like a trying. I'm trying for years. It's just, how do you control the beast that has been created? So that is a topic for the tech people to answer. But thank you, Hema. I hope I answered your question. I know I deviated. I apologize.
No, thank you, Shalini. You have been very upfront with your answers, and uh, I wish that the kind of power that you have exerted while answering it could actually be exerted when we use those devices or platforms for that matter. Um, yes, as Nandita has also rightly brought out that when we formulate the law, and as you were saying, I think the entire panel agrees on this that all the stakeholders should be given an equal voice when we come out with a particular legislation. And this includes the courts also. Courts are, as Arundhati said, mirror of society. So, what courts think, how the interpretation would work, how the technically we should be sound when we are drafting something. Because recently I was reading that even though India has brought in a law, but it would be soon outdated. It would be outdated before it is actually implemented, because there are a lot of gaps that we have left out when we are drafting it. And yes, there could be one reason could be the lack of relevant stakeholders. And yes, when we say that we are coming up with something that belongs to children, we should hear what children have to say, and how well we harmonize the definition of a child from global perspective, and what would be the consequences of when we transfer the data. And as Arundhati was rightly pointing out, and Nandita is pointing out, I think every panelist has pointed out this concept which is now known as sharenting. So, how parenting and sharing of information is being interplayed, and it's actually happening, is also important in the digital world. I thank you all for your time. I think we have exceeded 16 minutes from what we were supposed to end this conversation, but uh, a very warm thank you to Shalini, to Nandita, to Arundhati for coming in, for sharing your thoughts on a Saturday morning. I know for most of us it's a weekend, but thank you so much for coming in, for sharing your thoughts, for making people aware about topics. And I think when somebody views this a conversation of ours, they would be there would be a lot of questions. And I think for we have created another content for Suvir to bringing another discussion which would be more centric on certain topics. And this is Hema Sharma signing off. And I thank Bar Council of Punjab and Haryana for being very proactive on these topics, because these are things that require discussion, that require debate, that require understanding, at least from the legal fraternity, which is considered to be more aware of topics than the other citizens are, and who are concerned more about laws and how these are implemented. Um, I think
Thank you, Hema.
Thank you so much.
welcome,
Thank
welcome,
you.
welcome, and hope to see you all soon in another interesting topic, uh, which we can deliberate upon.
Thank you very much.
Thank you.